Hello everyone, welcome back to Believer Science Academy Bengaluru. This is topic of the day discussion, and in today's topic we are going to discuss about a very important topic, that is places of worship act. Okay, that is recently there have been some Supreme Court rulings regarding this places of worship act. We will see what are the rulings and what are the implications of those rulings and what is the recent judgment of the Supreme Court, and we will also see the background to this places of worship act and what are the issues related to worship act. Okay, so it is in news because the Supreme Court of India has directed civil courts to two things: refrain from registering new suits challenging the ownership or title of the places of worship, and second one is avoid ordering surveys of the disputed religious sites until further notice. This aspect becomes very important. Avoid ordering surveys of the disputed religious sites until further notice, because at present there are many surveys which were happening under the Place of Worship Act to determine the character of a particular religious place, but that has been also put on the hold by Supreme Court now. Additionally, pending suits have been restricted from issuing effective interim or final orders, including surveys, until the next hearing on February 17, 2025. Okay, so there will be next hearing on February 17, 2025, and the court said that until such or until the next hearing, do not give any interim or any final order regarding the existing suits, or also do not give any provision for surveying future religious places also. Okay, why this judgment becomes very important? Because it goes against the judgment which is given by Supreme Court in 2022. Okay, we'll see that. Before that, we'll understand the background of Places of Worship Act of 1991. Okay, so Places of Worship Act of 1991. What is its historic context? It was enacted during the Rama Janmabhoomi movement of late 1980s, which aimed at constructing Ram temple at Babri Masjid site in Ayodhya. Okay, we might have seen about Ratha Yatra, which was conducted by L.K. Advani, which was spearheaded by BJP, and the reason behind was to create awareness among the Hindus that the Rama, like place of birth of Rama, Lord Rama, has been occupied by the British. Sorry, not the British, occupied by the Muslim, Muslim mosque, that is Babri Masjid. So we have to destroy it and reclaim our land for Ram Masjid. Okay, Ram. Okay, Lord Ram temple in Ayodhya. So that was the Rama Janmabhoomi movement, and court or the government at that time, they understood that we cannot let this happen, because if one thing is happened, like if we are able to provide this or continue with this movement, that is if we are able to convert Babri Masjid into Ram Janmabhoomi or Lord Rama temple, then it is going to have Pandora effect. What is Pandora effect? We are just going to open the box and there will be many cases, such and such cases. Okay, because see, India is a country, okay, with a lot of history. In those lot of history, there will be many kingdoms, many religions, and many castes or many sub communities have reigned power over different phases of history. Okay, in one phase there was Buddhism, which was the prominent religion or prominent communities, and which was portrayed by patronized by government, patronized by the rulers. And then there was Jain rulers, and then there was Hindu rulers, and then there was Christian rulers also, and then there was some within Hindu religion there were Bhagavata rulers, and then there were Vaishnava rulers, and then there were Shaivite rulers, and then with the conquest of or the advent of Turkish rulers and Arab invaders, then there were Muslim rulers, and post-Muslim rulers there was Britishers, so Christians, and Sikh rulers were also there. Okay, so India has gone through phases of history where each and every religion or each and every community has had some sort of power at every certain point of period. Okay, so most recent was Britishers. Before them there was like Mughals or Muslim leaders. Before that there were Hindus. Before that there were Jains. Then Buddhist. Then Aryan, etc., etc. So there have been many temples or many mosques or many masjid basadis or many Buddhist temples or stupas have been built over the year, and the nature of these temples or these monuments have changed over the period of time. Okay, so now you are going to say that recently what the masjid was built by the Muslims was previously Hindu temple, and another community can go and ask that what the temple was there. Before the temple there was Jain masjid, and another community can go and say that before there was Jain Basid, there was Buddhist stupa. The Buddhist stupa has been converted to the Jain Basadi, and Jain Basadi has been converted to the Hindu temple, and Hindu temple has been converted into Muslim masjid. Okay, so there will be no end. Similarly, another community can come and there is a temple, but before the temple there is mosque. Okay, converted back to mosque. Another community can come that before the mosque there was dargah, before the dargah there was stupa. Okay, so there is no end to this one. So they understood that, the government during that time, they understood that if we let this happen, okay, we allow this to happen, then there is no end to this. Okay, so in order to avoid future implications, or in order to avoid future skirmishes of this nature, what they decided was, they decided to bring an act, decided to bring a parliamentary act. That is, the act was introduced by P.V. Narasimha Rao government to prevent similar disputes in the future. Okay, whatever the dispute has been happening till now, we don't want to have similar disputes in the future. So what we are going to do is, we are going to bring in an act, so that that act will end any sort of disputes on the communal aspects of any religious places. Okay, as a result, the act that was brought was Places of Worship Act of 1991. So what are the objectives of the act? Okay, objectives, if you know the background, you know the objective. That is, preserve the religious character of the places of worship as they existed on August 15, 1947. That is, if a places of worship was a masjid before independence, that is August 15, 1947, let it be a masjid. If a place was a temple before independence, let it be temple. It doesn't matter what it was before 200 years. It doesn't matter what it was before 500 years. As long as it was a temple, as long as it was a masjid, as long as it was a church, as long as it was a basidi, as long as it was a stupa, as of August 15, 1947, let that be. Okay, let that be. It prohibited conversions both within the religions, because within the religions there will be many sects. Because example, in Islam there are Shia and Sunni, and within Hinduism there are Shaivites, Brahmanism, like Shudras, etc., etc., and within like Buddhism there is Hinayana, Mahayana. Within Jainas there are Bhadigambara, Shvetambara. So these sects are present in within religions also, within denominations and between religions. It prohibited conversions within and between religions. Okay, UPSC can play tricks with your minds, and there can be a statement of places of respect, where they can say that it prohibits conversion between the religions, and but not within the religions. Okay, if the statement is there, that statement becomes wrong. Okay, see, I am emphasizing on these kind of things because they are very important. They carry a significance in UPSC prelims also. That is why whenever I say I emphasize on a particular word, like take note of this one. Okay, pay importance to that one. And then, so what are the structure of the act? There are certain provisions. Each provision dealt with different aspect of the places of worship. Section 1 and 2, it dealt with titles and definitions. Okay, what constitutes places of worship and what is the definition of places of worship. Section 3, it prohibits the conversion of places of worship. Okay, so there are certain places of worship, we should prohibit the conversion of those places of worship from temple to masjid, or masjid to temple, and so vice versa. In section 4, it declares the religious character of a place of worship and bars court jurisdiction. This aspect of this one, okay, this aspect of the act was the most contentious one. Okay, so what is it doing is, it is declaring a religious character of a places of worship, and then once it is declaring a religious character of a place of worship, it then bars court jurisdiction. That is, it is taking away judicial review. It is taking away judicial review. Okay, so judicial review has been taken away by this act. So which judicial review is part of the basic structure doctrine. So Parliament, or for that matter anyone, doesn't have the right to take away basic structure doctrine or take away judicial review. So this aspect of this act, okay, had become a very controversial aspect. Then section 5, it exempts the Rama Janmabhoomi Babri Masjid dispute. It said that this act is going to affect retrospectively to all the like other religious places of worship except Rama Janmabhoomi movement, because it was already under contention, because there was already movements happening, because there was already lot of debates and discussion going on that. Okay, so this act exempted only this Babri Masjid issue, and other things it affected retrospectively. That if there is any like suit, or if there is a dispute going on between any communities regarding particular place of worship, that cannot be carried forward because this act restrict that one. Okay, and what are the key legal provisions? In key legal provisions, section 4 clause 1, what does it say? The religious character of a places of worship as of August 15, 1947 must be upheld. Meaning, if it is a temple as of August 15, 1947, it should be left to be live as a temple itself. It should not be converted to masjid, it should not be converted to church or etc. Then section 4 clause 2, it dealt with existing suits or fresh suits, meaning any cases pending cases on conversion before August 15, 1947 shall abate. Okay, if there are any pending cases, that are also going to be abated. New cases on the same issue cannot be initiated. Okay, whatever the cases are there, they should be left away, and it whatever the like character of the place of worship is there before August 15, 1947, it should be maintained. Okay, and then, so what are the exemptions? There are certain exemptions. What are the exemptions? In a sense, exemptions to certain places of worship which are provided under this act is protected sites. That is, if any site is declared as a protected site under Ancient Monuments and Archaeological Sites Remains Act, okay, Ancient Monuments and Archaeological Remains Act, then it can be surveyed and then it can be converted, or it can be retained as per the wishes of Archaeological Survey of India. Okay, this aspect, okay, according to some critics, has been misused by majority communities. This aspect has been misused by the government for its political purposes. Okay, we'll see the examples in the coming cases. The resolved cases, disputes settled or decided before the act's enforcement. Okay, it resolves already cases which have been settled before the enhancement or enforcement of this act. Okay, act was enforced on 1991. If there is any case which has been already settled by the judiciary, already settled by between different communities, that temple or that place of worship also is to be exempted. And then mutual settlements, that is alterations agreed upon by all the parties before the act's enforcement or commencement. Okay, there is any a dispute regarding place of worship act and it has been agreed upon by the different communities or different stakeholders, then that place of worship cannot be taken forward. A fresh suit cannot be initiated against that one again. Okay, then so background of the case at present, what is the background of the case is the nature of case. So the present case on which the Supreme Court has released directives and it said no fresh cases should be taken away until the February 15 hearings of 2025. So what is the background of this case is the present case involves petitions questioning the constitutional validity of the Places of Worship Act, whether the Places of Worship Act is constitutional or not. Why? Because okay, before this we'll understand the Places of Worship Act and a timeline. So 1991 Place of Worship Act was enacted. It said religious character of a place of worship while it was on August 47 shall be maintained. Only exception was Ram Bhumi Babri Masjid. And in October 2020, first petition filed the challenging the act. 5 more petitions were filed subsequently on the grounds of arbitrariness on the date and the fact that takes away judicial review. Okay, so what is the purpose of having August 47, like August 15 and 1947 as the date? Okay, wasn't India there before August 15, 1947? Weren't there any communities? Weren't there any religions? Weren't there any castes? Or weren't there any temples, masjids, etc. before 1947? Why should that particular date be taken away? Okay, taken as a reference, and why it was taking away the judicial review? Why it was exempting or barring the judiciary jurisdiction with respect to this act? So they say that the petitions filed that it challenged the constitutional validity of the case based on the removal of judicial review. And in August 2021, 5 women filed suit in the Varanasi seeking permission to pray at Gyanvapi Mosque. Okay, Gyanvapi Mosque or Gyanvapi Temple, which is another one of the mosques or temple which is under the contention. Okay, Muslims consider it to be mosque and Hindus consider it to be a Shiva temple which has been converted into a mosque, which is present in Varanasi. May 2022, after case reached the Supreme Court, the then Chief Justice of India, that is D.Y. Chandrachud, orally observed that survey may not be necessarily fall foul of the Place of Worship Act. Okay, when the five women reached the suit, and it caused a stir, and many people were criticizing the move, and it went to Supreme Court. In the Supreme Court, one of the argument of petitioner was, in order to determine the Places of Worship Act, in order to determine the nature of the particular place of worship, in this case Canopy Mosque, the court should allow for surveying of the mosque. Okay, surveying done by the Archaeological Survey of India. The then Chief Justice of India, that is C.Y. Chandrachud, said that surveying doesn't mean that it is falling or it is against the Place of Worship Act, because the Place of Worship Act only prohibits the conversion of place of worship, and it only prohibits the fresh suit. It doesn't talk about surveying of a particular temple or mosque. So he said that surveying doesn't necessarily fall foul, meaning it is not violating the particular act. Okay, this judgment, that is survey can be taken by the Archaeological Survey of India or anyone in order to determine the nature of the place of worship, has been very contentious, because post this, between 2022 24, at least 6 suits were filed claiming past existence of a Hindu temple at the site of a mosque or a dargah. Surveys were ordered in the 3 of these cases. Okay, so there were 6 suits which were freshly ordered, or freshly filed in the court. They were claiming that there was a Hindu temple before a particular dargah masjid. Okay, and of these 5 petitions, or 5 suits, 6 suits, 3 suits surveys were ordered, meaning according to this, there is precedent has already been set by Supreme Court of India. According to this precedent, if you are not able to determine the character of a particular place of worship, you are allowing them to conduct a survey, because Supreme Court has said so, and Supreme Court has set a precedent there. Yeah, Supreme Court is a court of record under Article 129. Whatever the judgment Supreme Court takes can also be used as a precedent to other courts. So in 6 courts, or of the 6 suits, 3 suits were allowed to do the survey. Okay, this surveying again raised so many eyebrows and resulted in many controversies. So in December 2024, judiciary, that is Supreme Court, took up case again, and Supreme Court said that it barred further survey orders, further effective orders, and registering of fresh suits. Okay, so it is not just registering of fresh suit, it is not just determining the place of worship act nature, it is place of worship nature, but it is also the surveying that is prohibited. Okay, you cannot allow any more surveys under the place of worship act until we say so. Okay, so next hearing will be on February 25, 2025, 17, 2025. That becomes very important. It is going to determine the constitutional validity of place of worship act. Okay, so the key challenges to the act was, it bars judicial review, which is violating the base structure doctrine, which I already explained you. The retrospective cut-off date, that is August 15, 1947, is deemed arbitrary and irrational, limiting the religious rights of the Hindus, Jains, Buddhists, and Sikhs. Okay, because most of the places of worship which are converted into mosque or dargah belong to these communities, that is Hindus, Jains, Buddhists, and Sikhs. These are one of the arguments put forward by the petitioners. Then core legal questions before the court. Okay, what is the core legal issues before the court? That is central issue. That is, can district courts, by entertaining the suits on the ownership or the title of place of worship, undermine the purpose of the 1991 Act? Okay, they said that you cannot change the character of a particular place of worship. But what if the place of worship was owned by a particular community and claimed by another community? So it is not dealing with the nature of the religious place of worship act, but rather it is dealing with the ownership of the place of worship. Okay, can the ownership of place of worship act allows the district courts to entertain the suits on the ownership rather than the nature of the place of worship act? Okay, so Supreme Court has to address this issue. And then key developments in the previous rulings was, in 2022 observations, I already told you that surveying a place of worship does not necessarily violate the 1991 Act, which is given by C.Y. Justice Chandrachud. The Supreme Court highlighted the hybrid character of some religious sites where multiple religious symbols coexist. Okay, we cannot properly determine whether a particular site or particular place of worship belong to particular community or a single community, because of the long history of India, many of the place of worship, temples, masjid, etc., they carry symbols of many religions. Okay, suppose there is a dargah, example the Gyanvapi mosque. After the surveying, they found that there was Shivlinga present there, and there were also symbols of Gautama Buddha there. So it not necessarily belong to only Muslims there. So presently it is a mosque. So there obviously be symbols of Muslims there, but they found the Shivling there, and they found other motifs of Hinduism. They found motifs of Buddhism. So they claim that it is not necessarily belong to one community. It is belong to many communities. So many communities can co-worship there. Then Ayodhya verdict. Okay, the act was recognized as a part of the constitution's basic structure, which is crucial for preserving the secularism and communal harmony. Okay, in Ayodhya verdict, it said that it is part of basic structure. What is Places of Worship Act is part of the base structure of India doctrine. Okay, it is so contradictory because one of the provisions of this act is taking away another part of base structure of doctrine, that is judicial review. But even then, judiciary had that it is part of base structure doctrine because it is preserving or upholding the secularism and reducing the communal disharmony. And it also underscored the principle that historical wrongs cannot justify actions disrupting the present and future. Okay, be whatever the case in the past, whatever the religious rulers, whatever the religious fanatics have done in the past cannot be a reason for us to violate or destroy the peace of the present. Okay, so these were some of the understandings provided by rulings provided by Supreme Court. And in December 24, which already explained you, the key directions were no fresh suits challenging the religious sites ownership or character can be acted upon. Okay, pending cases will not progress until further notice. And then the Union government was asked to clarify its stance on the constitutional validity of the act within 4 weeks. Okay, see the judiciary's power. The understanding or like determining the constitutional validity of a particular act is the duty of the judiciary. But here, judiciary is asking opinion of the government itself. First, you tell me whether it is because the law has been made by the government itself. Like maybe the government has changed now, but the government of the past made the law. So it is asking the executive, you tell me whether it is constitutional or not. Based on your opinion, we are going to take up the case. So that is the power of judiciary. So observations are that lower court must respect the principles outlined in the Ayodhya judgment. Okay, that is place of worship. It is a basic structure doctrine, and you cannot bring ownership of a particular site into the contention and override the religious character of a particular place of worship act. Even without the 1991 act, the constitutional principles may prohibit suits altering the religious site character. Okay, this ruling, this point is very important. Supreme Court observed that even without the place of worship act 1991, the very character of the Indian constitution, okay, constitution of India is of secular nature. Because it is of secular nature, it prohibits altering religious character of a particular place. Okay, so there was no need of 1991 act. If wanted, Supreme Court can deal with this act based on the secular aspects provided in the Constitution of India. Issues concerning the judicial review powers restricted by the act demand further scrutiny. Okay, so the judicial review has been restricted by the act. That has to be scrutinized again, but there it requires certain scrutiny in the future. Okay, that only act or that only aspect cannot be a reason for removing place of worship based on the constitutional validity. So, in conclusion, Supreme Court directives aim to uphold the spirit of 1991 Act, emphasizing communal harmony and the preservations of India's secular fabric. However, the constitutional validity and the broader implications of the Act remain under judicial examination. The next hearing is on February 17, 2025, which is expected to provide further clarity. Okay. So this is the topic for the day, which I will dealt in a holistic way with the background, with the current context, and with the judicial rulings. Okay, it becomes very important for people who are preparing for interview as well as people who are preparing for prelims as well as mains. There can be direct question in the prelims as well as mains regarding the provisions of place of worship act, or in the mains regarding the communalism or secular fabric of Indian nature. Okay, so if you have any doubts, you can write in the comment box, and if you like the video, please click on the like button, also comment on it and share with your friends. With this, I will end the video. Jai Hind.